Well, greetings, Who Knew fans from across the world. We are so delighted that you are joining us this afternoon. My name is Tom Truitt, as you see on your screen, and I want to welcome you to our first installment of the Smartest People in the Room. And to launch this program, I have selected absolutely two of the smartest people in any room, let alone a room that I happen to be in. And speaking of room, I am pleased to be broadcasting this from a very special room in Nashville, Tennessee, Grimey's Pre-Loved and New Music, which is one of the most iconic record stores, not only in Nashville, but also in the entire USA. And I'm going to talk a little bit more about Grimey's later on, but I just wanted you to understand how literally we are taking the concept of room, of the smartest people in the room. Let me take care of a little bit of business here as we get started. I want to thank our sponsors for without all of their support, we could not do what we do. So very quickly, if you'll indulge me for a moment, I want to thank First Horizon Bank, Bufkin Baker, which for those of you who don't know is the search firm that I work for. I am a music industry headhunter. I place senior level music executives in jobs throughout the industry. If you're interested in hiring or being hired, hit me up. Core Power Yoga, the Fairlane Hotel, Lightning 100, which is the greatest radio station in the world out of Nashville, Tennessee also. Create Tennessee and the Tennessee Entertainment Commission, Tennessee Brew Works, Four Roses Bourbon, which we'll be talking about a little bit later in the program, Moo TV, Jive Printing, Project Music, and also Organics. Those are our sponsors. I want to thank each of them for their support of Who Knew from the start. I'm giving a virtual clap to them, and I hope the rest of the audience will do the same.
I like some of those logos.
They're awesome.
The Brewworks logo is excellent. Four Roses, excellent.
Well, thank you. Well, folks,
I mean, they're all good, but those two in particular are very good.
So as you can tell, our moderator today, Jim Griffin, is eager to get started as he's jumping in here. So let me tell you a little bit about Jim Griffin, because Jim is one of my best friends in the music industry. In fact, best friends in the world. Jim is the original inspiration for Who Knew. And I could not launch Smartest People in the Room without him, because he is truly the smartest guy in any room that he goes into.
Except this one.
Jim, people in the music industry will know Jim as an expert media technologist, well-schooled and experienced in the ways of digital media and its monetization, especially music and the text, graphics, and video that accompany it. Founder and moderator of the FA List for over 15 years amongst the best global communities for digital music and media. That's Jim Griffin. And as Jim's guest in the Smartest People in the Room series today, we are delighted to invite Damien Riehl. And let me read a little bit about Damien for you. A classically trained musician, lawyer, and technologist with a BS in music and with experience in complex litigation, digital forensics, and software development. A coder since 1985, and for the web since 1995. Damien clerked for chief judges of state and federal courts, practiced in complex litigation for over a decade. After that, he has led teams of cybersecurity and world-spanning digital forensics investigations, and more recently led teams in legal software development. An appointee of the Minnesota Governor's Council on Connected and Automated Vehicles, he's helped recommend changes to state statutes, rules, and policies, all related to connected and autonomous vehicles. At Fastcase, where he works currently, Damien helps lead the design, development, and expansion of the Fastcase legal research platform, integrating AI-backed technologies to improve legal workflows and to power legal data analytics. Ladies and gentlemen, that is a long paragraph just demonstrating a little bit about how smart this guy is. And so I cannot wait to hear these two geniuses go at it. Jim and Damien, welcome to the Smartest People in the Room. Take it away, please.
Thank you very much.
I got to say, thanks for having me. I'm really attracted to guys like like Damien. It's fascinating to hear him call himself a tech lawyer or a lawyer, law technologist. I think I'm a media technologist or a music technologist, and that's interesting. I don't have a BS in music, and I just love that phrase, BS in music, because there is a lot of BS in music, no question about it. And he's got a degree in that. I got to say, Tom and I encountered Damien after he gave this TED Talk about all the music. And by the way, you can go to a website called allthemusic.info, and it will give you all the information about all the music. But if there's a hook out there that's baited for me to bite on it and get reeled in, and certainly this happened to Tom, it's All the Music Project that was the subject of the TED Talk that Damien did. It's an extraordinary project, and I don't think the verdict's in on this. I think it's a subject of great discussion. And in fact, I assert to you that it is performance art. I don't think he really wants to copyright all the music. I think he'd rather it wasn't. But therein lies the discussion. So, Damien, if you would, tell us about how All the Music came to you and what you're up to with that. By the way, mindful that Attack Magazine had a headline, "Musicians use hacker algorithm to generate every possible melody," which is kind of a funny statement to make about what you're up to with your musical partner there. So give us the best introduction you can and help absorb our uncertainty about what you're doing to the music business with these machines.
Sure. First, thanks, Tom, so much for asking me, and Jim for asking me to be on. I'm thrilled to be on. The way that All the Music came, it was a long time coming. As Tom mentioned, I've been coding since '85, for the web since '95, so I've always had tech passions at heart. I took those tech passions to law school, and during law school, I learned about a copyright case involving George Harrison, where George Harrison was sued by the Chiffons, and the Chiffons saying, "He's so fine," and George Harrison saying, "My sweet Lord," and Chiffons sued him. And the court in that case said, you know, George Harrison, we don't think you consciously copied the Chiffons, but we think you subconsciously copied them, which always stuck in my craw in law school, because I thought, gosh, you know, every other element of the law, if I punch you in the nose, if I punch you on purpose, that's way different than if I accidentally punch you in the nose, right? One is, assault with intent, or, you know, intentional murder. But so in every other area of the law, intent matters. But in this area, you could accidentally be said to be infringing copyright. So I took that to me, so I stuck that in the back of my head as being unfair. Fast forward to working on with Strauss Friedberg, which is a cybersecurity firm where we worked with a bunch of, if you get hacked, we would go in and get the bad guys out. Part of our work was to, and I was thinking about the cybersecurity work, excuse me, how if I as a hacker wanted to hack your password, I could do that through brute force. I could take a computer and quickly go AAA, AAB, AAC until it guesses your password. That's called brute forcing a password. So I thought,
and well, not guessing.
Without guessing, right? Just exhausting mathematically every possible combination of letters. And so I thought, you know, right behind me is my music studio, and I work a lot with MIDI. And I know that MIDI is a representation of music. And I thought MIDI represents music in much the same way as computers represent letters. So I approached my colleague, Noah Rubin, who is one of the smartest people I know and a great, great programmer, and my colleague in this. And I said to Noah, I said, do you think you could brute force music by just incorporating MIDI into essentially the hacker algorithm that would brute force passwords? And he said, oh yeah, that's easy. And within 2 hours of programming, he had created a prototype that created hundreds of thousands of melodies within 2 hours of programming.
You use that word created kind of loosely, don't you?
That's right. That's right. So he created the code, which then when he hit run on the algorithm, the computer generated the music.
Some would dispute that is creativity at all.
That's right. I would argue, so yes, that is a dispute. Query how different that is than me as a photographer hitting the shutter on the camera, which then creates processes to capture the image. Is my hitting the shutter on the camera any different than Noah hitting run on the computer?
Well, we know that if a macaque hits the shutter on the camera, it's different.
That's right. That's right. And so that's the question. So the real question is, who created these works? Did the machine create them, or did the human that presses the shutter of the photograph of the camera, or the human that presses run on all the music algorithm? Who is the creator of that work? And that really, the answer to that question is still the open question. And there are two ways to maybe think about that then. First way is Yes, it is copyrightable, because just like a photograph is copyrightable, ours is copyrightable too. So if copyrightable, then we have ostensibly—
as long as you fixed it in the medium.
That's right. And to be clear, as soon as he hits run, it went to a hard disk, which is under copyright law a fixed tangible medium. Much like I would just record something, that's a fixed tangible medium too. So as soon as it's written to disk, it's a fixed tangible medium that under the Berne Convention, you don't need to register it. You don't need to do anything formal. It is copyrighted automatically. So anyway, so if copyrightable, then maybe, so what we've done is placed everything that we've done into the public domain, under, at least ostensibly, under Creative Commons 0. So saying that anything that we have copyright to, anyone can use without having to pay us royalties. So that's if copyrightable. If not copyrightable, the real question is, why not copyrightable? Is it not copyrightable because our computer system just mathematically exhausted every melody that ever can be, and if that's true, and if it's just math, then is any melody copyrightable? If we're not copyrightable because what we've done is just math, that is just a fact, that is not copyrightable, then really if your melody in your song that you, human, created is identical to my melody that I created with a machine, what makes yours copyrightable but not mine copyrightable?
Right, now there's two discernible arguments there that you crossed over into, right? Because you moved into Feist territory with the end piece, which Feist versus Rural Telephone Company, telephone book being a bunch of facts, not copyrightable because it is a bunch of facts. Your initial setup being, is it creative or not? So those are two different discussions that attack the notion that what you're doing is copyrightable.
That's right. And I'm going to show on my screen something that might help the users a little bit to be able to visualize what we're talking about. What you see here is essentially every melody that's ever been in red and every melody that hasn't yet been in white. And the premise of the All the Music project is that we have mathematically exhausted every single spot in here, the white spots and the red spots. And so really, under this frame of thinking, any songwriter on the bottom left that is picking, has from time immemorial picked a melody, they have actually plucked it from this already existing finite mathematical data set that we at All the Music have just filled in all the spots. So we filled in both spots that haven't yet been taken in white and spots that have been taken in red. And I would argue that there's also a third type of spot, which is public domain works, say Bach, Beethoven, and Mozart, that were copyrighted back in their day, but have lapsed into the public domain. I would argue that those are gray spots. And so a way to think about it is, how many gray spots of Bach, Beethoven, and Mozart overlap the red spots of songs that are copyrighted today? And if that red spot already was a gray spot in the public domain, what right does the person who wrote the red spot have to sue somebody over something that was a Bach song or a Mozart song? And that really brings into the fore really the question as to what is copyrightable and not. Here's a list of the data sets that we've created. We've been able to create major and the minor, do, re, mi, fa, sol, la, ti, do, and then we did 12 notes repeating. Then we did the minor 2. We also did chromatic scale, so including the black notes and the white notes. That was after my TED Talk for anyone who watched that. And then we also did an octave and a half of both the major and the minor scale. So that would be the A minor octave and a half, and then also the C major with the white notes. And then another thing that we created here is the idea of rhythm. So we've created 13 pitches, and then the 14th note is silence. So for any of these 10, then you are you can have silence for one or more of those. So that creates eighth notes, half notes, quarter notes, whole notes, etc. So as you can see, it really expanding the number of melodies in our data set is just a matter of math. It's just a matter of expanding your parameters, saying, okay, now instead of 13 pitches, I'm going to expand to 15 pitches. And instead of 10 notes across, I'm going to expand to 15 notes across.
Now, Damien.
So, yes.
My lawyer of choice is Daniel Novick, and he just did post something in the chat, and he referred to the human authorship requirement in copyright. And it makes sense, right, that copyright under the US Constitution must be an incentive. And we really can't incentivize machines, so it's all about incentivizing humans to do things. And so how do you address that requirement that we are really looking to incentivize machines? That would be wrong. So incentivizing humans is the whole point of copyright, and this misses it.
So I would agree that, you know, generally the point of copyright is to incentivize things and to be able to create more music. And I would argue that, you know, I guess the biggest question for me is that if I am Beth, who accidentally stepped on that melodic landmine of Adam's song that was read, if I happen to pluck out of the finite data set something that Adam had already plucked out of the finite data set accidentally, Beth has created something, but Adam being able to sue Beth de-incentivizes Beth from making new music, or at least makes Beth really worried that she's going to get sued over a song she's never heard before. And so under the current copyright law, that I think that the questioner is right, that we under copyright law need to incentivize everyone, Adam and Beth, to make more music. But actually the result of our current George Harrison copyright law of subliminal infringement, Beth is almost always going to lose. Therefore, Beth is actually de-incentivized to make more music. And Adam is incentivized to sue Beth all the time, therefore creating less music. So I would argue to the first premise, yes, you're probably right. We do need to incentivize under copyright law. And our current system, number 2, does not do that. And then I think where the questioner was going was saying, Damien, what if you've exhausted 200 billion melodies, which is what our data set currently is, and if we're going and we're keep making more, you know, I would say that, okay, if we take the idea of copyright of the melody off of the table as far as something that is monetizable, there's still all sorts of all sorts of musical aspects that are fully copyrightable and are fully incentivized, that I can make a music and be able to copyright my recording, copyright my arrangement, copyright my lyrics plus recordings, everything. Let's just take melody off the table and you still have those incentives.
Well, we're going to move on in a minute, but before we move on, I just want to take a pin and pop this balloon a little bit and say that I'm going to assert for the moment that you're not going to register any of these copyrights, if they are copyrights at all. I think you've said that. You've pointed out you have no intention of being a plaintiff in any kind of a copyright matter. So you have no intention of registering any of these works. And to the extent that people think you're claiming copyright all of this, you're not. You're really poking a hole in the whole idea of what is copyrightable in the first place.
That's exactly right.
That's why I call it performance art. You know, this is fun to talk about. And you've certainly provoked people as an agent provocateur. But in reality, this is not how you intend to pay the bills.
Absolutely not.
Having induced an algorithm to do all of this work of generating all of these melodies, and then you're not going to claim them, and you're not going to ask people to pay you or send you royalties of any kind. You have no intention of depleting the royalty pool at all. Although I'm sure the black box has some money for you.
I'm really glad you brought that up, Jim, because yeah, that's something I've tried to make clear in my TEDx talk and otherwise, is that we are not a sword, we are a shield. So the whole point of this is to be able to protect Beth against lawsuits where she has never heard Adam's song before. So the Beth, at least under the idea of our project, is that if Beth can say, hey, listen, Adam, All the Music has also written these things. Actually, All the Music's project was in 2019, and you, Adam, wrote your song in 2020. So this, this machine wrote to disk and either copyrighted the thing that you're trying to say is yours, or put into the Creative Commons Zero the things that you say is yours, or it's not copyrightable at all, Adam. So why don't you stop suing me? The whole point is to protect Beth and to be able to let Beth make more music without looking over her shoulder and worrying about getting stabbed by Adam over a song of Adam's that she's never heard before. And to your point about money, we've not made $1 yet on All the Music project, nor do we anticipate actually making any money at all on this. Largely, I saw an injustice, and Noah saw an injustice that we'd like to right, and we've spent a lot of money to make $0.
Well, as you can tell, I've turned off the Bar Association filter that might have run on top of this discussion. You've declaimed you don't want to make money off of it. You have no intention to generate any billable hours. So we're going to walk away from that. But we're going to walk towards a subject that is my favorite subject is regarding you. I mean, people don't know that you work for this company, Fastcase. I mean, it's not that it's a secret of any kind, but Fastcase being such an important company, at least to my own view of the law, I really want to go there, and I want to understand you better as regards your work at Fastcase. Fastcase has, I think, almost 1 million subscribers. Founded in 1999, Ed Walters is the CEO of the company. And what you've got 32 state bar associations signed up. And you basically have created a database of court filings. Is that correct?
All of that is correct thus far. Is that our co-founders 20 years ago saw that legal research was really expensive. The incumbents in the duopoly is Westlaw and Lexis, and so they thought, I want to democratize the law. Ed and Phil said, so they created a third company, Fastcase, to be able to provide to a lower cost alternative to Westlaw and Lexis. And we are now, after 20 years, we just celebrated our 20-year anniversary, providing things that actually are going to exceed, I would argue, the incumbents. And part of my job is to help that acceleration process go forward. And to add on to what you said, yes, we have all of the cases that relate to all 50 jurisdictions and more than 50 jurisdictions. We also have as many regulations as you can imagine. We also have statutes. We also have bar association materials. We also have secondary materials. We have essentially everything that composes the DNA of the law. And my job is to help extract the DNA of the law, be able to count all the things that wins and loses lawsuits, or the things that makes things riskier or less risky. Whatever moves the needle, I select the things that is going to move that needle, I count them, and then I feed them back to lawyers in a way that is useful. So an example is that if I am litigating a case in the Southern District of New York in front of Judge Smith, and it's a breach of contract case, the things that we're building is that I, at Fastcase, am going to give you, that lawyer, both the cases that are more likely to win in the Southern District for breach of contract cases for Judge Smith, both cases that are more likely to win and legal arguments that are more likely to win for that judge, for that type of case in that jurisdiction. So this way, it's by extracting the DNA of the law, you're able to feed back. You can imagine a first draft of a brief that says, for Judge Smith, here are the arguments that are statistically more likely to be persuasive to Judge Smith.
So if I understand it right, you decided that you would democratize the law, which to you means lowering the price of the law, and yet 32 state bar associations signed up quickly. That is wild. I mean, I have to say, hats off to you for convincing them to do that.
Well, and the benefit to the bar associations and the benefit to us is obvious. I guess not really obvious, but it's brilliant for Phil and Ed to do this. The bar associations give us money to provide their bar members free legal research. So you as a lawyer who are a member of, say, the New York State Bar Association or to any other bar association, you don't pay a dime for Fastcase. The Bar Association pays Fastcase. So in that way, we at Fastcase get access to 900,000 plus lawyers, and we also don't have to nickel and dime those lawyers for individual sales for solo small folks especially. We just work with the Bar Association. So it's a win-win all the way around that we provide a lower cost alternative, and I would argue as good a product as what you'd pay hundreds or thousands of dollars for.
And as I understand it, this is available in prison libraries.
That's right. That's right. So part of the idea of democratizing the law is that judges write cases. Legislatures write statutes. We as taxpayers pay those judges, and we pay those legislators to do that. So it seems silly to have to pay the judges to write something and then pay again to get the benefit of that judicial opinion. Democratizing the law, to Ed and Phil, said, no, we should pay once with the tax dollars and then make that free for everybody and not charge for access to the thing itself, but charge for the thing that provides value on top of that. So part of that work, as you mentioned, is for prisons and jails. If I am a jailhouse lawyer that is defending himself.
No, they let Michael Cohen out yesterday.
I'm sorry, say that again?
They let Michael Cohen out yesterday.
Right. That's really funny. Oh, there's so much to say there, but I'm not going to say it. But so yeah, so yes. So if you're somebody who's not maybe Michael Cohen because he's now out of jail, but if you are still in jail, you can. Lots of jails have contracted with us to be able to access the statutes and the laws in case law and otherwise that would be applicable to their cases.
So let's say you're my buddy Daniel Novick in Nashville, an attorney who I hold in high esteem and who does a lot of dealing with publishing catalogs, for example, or catalogs of music. Could he enlist you to provide him research related to certain ISRC codes and or ISWC codes, thereby helping him value or detect problems in catalogs? Would this be something that attorneys in the music business could make use of, quite aside from their pleadings in courtrooms and so forth?
That's right. So yeah, yes. So the idea is that anything that is text-based, you can extract from it and tag it. So one could imagine, for your example, the particular code that you're looking for, just write the letters. Is it ISRC? I'm sorry.
Well, yes, the International Standard Recording Code refers to the globally unique identifier for sound recordings, and the ISWC code refers to the globally unique identifier for works or compositions, publishing assets.
Got it. So, so to the extent that that text ISRC is in a text in our data set, of course, it's trivial. It's easy to be able to extract ISRC from it, and also trivial to say, okay, give me the number next to ISRC, and then be able to then take all of those ISRC codes and maybe do a cross-reference, maybe with a different database, to be able to say, okay, here's a database of all the ISRC codes, and be able to say, okay, here in that other database is the owner of that work. And then once you start merging those data sets, you get to really cool things, because in our data set, we have cases. And as part of the cases, you have both the litigants, who's suing whom in the case, and you have judges, you have jurisdictions, New York or California or Texas, and you have the cause of action. Is it a breach of contract case? Is it a copyright case? And what is the thing being fought about? So once you combine those data sets, what song is being fought over, who owns that song, and then cross-reference that with who are the litigants in the cases, and which judges were they before, and which jurisdictions were they in, you get a really good sense, if I have, say, a catalog of works, the extent to which those works have been fought over, for one. And then with number two, something probably too detailed to go into now, is there's something called a graph database, where not only can you say, okay, which litigation has this particular song been in, but you can say, much like Amazon says, people who like this book often like that book, you could say, this song is a lot like that song, and that song has been litigated a lot. So you can be able to extrapolate and say, much like Spotify says, if you like this song, you might like that song. We could say, this type of song gets litigated a lot. So just because that song that you're looking at hasn't been litigated, maybe the risk of it getting litigated is a lot higher than another song. So that's the power of, once you extract the data, you can make correlations and risk assessments in ways that aren't licking your finger and putting your finger in the air.
So I want to know what the bad law bot is. And then how could I arrange to release it on a resort during the holiday times, or maybe Grand Central Station tomorrow afternoon? What does the bad law bot do? And how does one arrange to have it work on your behalf?
The bad law bot is a very clever marketing term that sadly underpins relatively mundane technology. The beauty, AI, I often say, is if you understand, the question is it AI? If the answer is, do you understand the technology? If the answer is, no, I don't understand it, it's magic, then yes, it's AI. If the answer is, oh no, I totally understand it, it's not AI anymore, it's just software. So I would say that bad law bot, if you don't understand it, is magical. It just provides you the right answer. If you do know how it works, it's just smart people writing smart code to be able to do what took humans a long time to do in the past. So for example, bad law bot in the fast case universe, it goes through and I used to work for a large legal publisher based in Minnesota that I'm not going to name, that employs lots of people to be able to say whether a case has been overturned or not. Is that case good law or is that case bad law? That, of course, paying a lot of humans to do that costs a lot of money. So what Fastcase has done is done that through code, to be able to determine through code that one case says that case C says that case B overturned case A.
The screen is frozen for me.
Yeah, we've lost Damien. Can you hear me, Jim?
I can.
Yeah, Damien froze up. So, hey, folks, while we've got this moment here, let me ask you to keep sending me your questions. I am feeding them to the panelists. Jim, I've sent a couple directly through to
I've got
you.
them now.
Yeah, so they're coming in from some friends of ours who want to know a little bit more about the All Music project and from a technical standpoint and a legal standpoint. So we'll get to those in just a moment.
We definitely will as soon as we get Damien back.
Uh-oh, now we've lost him altogether. So hopefully he'll
Well, that's good. That's probably a recycling process that will have him back in front of us in just a moment. Tom, could you tell us a little bit about Grimies?
Yeah, thanks for asking. Grimies is run by a long time.
Those are the words above your head, by the way. That's not a halo.
That's right. That's right. Grimies, the name Grimies comes from one of the founders and owners, a guy named Mike Grimes, who is an icon in Nashville, and his business partner is a longtime friend of mine, Doyle Davis. Fun fact about Doyle, Doyle spoke at the second Who Knew ever. So our little program's come a long way in the last 5 years. When I started planning this event, I wanted to give some love to rooms, and Grimies, like a lot of small businesses, needs all the love that it can get right now, but don't feel sorry for them. Doyle has done an incredible job managing through COVID. In fact, they have launched a very, very, I guess, active mail order business, and they have done just incredible numbers. They sold 800 copies of the new Jason Isbell record before it was released. They've sold over 200 signed prints from Jason Isbell in the last couple of weeks. They've just launched the Haley Williams new record and sold 200 advance copies of that. And this is all being done on mail order. They've got a curbside delivery service now that fans of Grimies locally can just drive up here and honk the horn, and the folks will come out and hand the record off to them, put it in the trunk of their car, so no human touch. Anyway, Doyle and his team have been very nimble and pivoted in a very interesting way, and they're going to come out of this COVID thing stronger and better than they were before COVID.
Well, with Damien, they could probably generate new stuff and deliver it curbside within a half an hour.
Yes.
Stuff that hadn't been released before. Their own logo looks like a Yes album cover, I'm convinced.
So despite the technical difficulties we're experiencing here, let me take a moment and also talk about what we're going to be doing next week on this same program. Jim and I are very pleased to be bringing Bob Lefsetz to the Smartest People in the Room series. Bob Lefsetz really needs no introduction. If you're in the music industry, you know who he is. He's the industry's most vocal and probably most widely read blogger. Bob's not afraid to take an opinion or put out an opinion on anything, and we expect a rollicking discussion between Jim and Bob next week. That one,
I don't think I'll get a word in edgewise, and I really would not want to.
Well, that's going to go down at 3:30 Central, 4:30 Eastern next Thursday, and there is Damien right on demand again.
As much as I love Comcast, Comcast, it looks like it just went out in my neighborhood. So I'm now talking to you from a Wi-Fi hotspot on my phone. So one hacker idea is that there are many ways to do the same thing. So apologies for
there was
Comcast.
Speculation that the man got you.
Well, maybe
the bad law bot got you.
It's true. With as many industry executives on the line as there are, I'm not going to disparage Comcast, but that may well be the case that the man may have gotten me.
Yeah,
you've gotten away. Now I have T-Mobile, so that man has not gotten me.
Well, they're coming, so be ready for it. There are a lot of questions for you. I don't want to go backwards at the moment. I do want to get to those questions after this, but tell me, the docket alarm. Tell me that that's not something that reminds you to bill your clients on a regular basis.
It is not, but though that is an important aspect of one's practice.
No question.
Docket Alarm was founded by somebody that is a lot like me, a guy named Michael Stander, who was a coder, coded for a long time, went to law school, became a patent litigator in a large white shoe law firm, and like me was frustrated with the state of legal tech. So he built a thing, Docket Alarm, to be able to solve a problem that he had, to be able to, he as a patent litigator had to have a whole portfolio of cases that he had to track. So what Docket Alarm does is collects the dockets, that is the complaint, the answer, and everything that happens in a particular case. It is able to track those dockets, not only the dockets, what happened, but the underlying documents that is the complaint, is the answer, is the motion to dismiss, is the judge's order. So he collects dockets and documents in a massive data set. His data set at this point is, I would argue, one of the most expanded.
Wi-Fi hotspots are tough.
So, Jim, you and I get to tap dance a little bit more for a moment. I really appreciate you doing this from the spot that you are located in today. Where are you, Jim?
I'm in the school system in Warrenton, Virginia.
I'm now back. Can you hear me now?
There you are. Very good. And it is like a Verizon commercial. So.
It is. It's true. It's true. Sadly for T-Mobile. Maybe T-Mobile has gotten to me.
Yeah, we can hear you now. Now, I'm going to slip back and ask some of these questions because people have a real interest in, for example, thinking about software as facts and why these same circumstances don't apply there, or what are the differences between software and, say, generating music.
It looks like you're frozen on your side. Can you hear me on my side?
We can hear you, but,
okay.
But your image is frozen and now it's back. So that's
awesome. All right. So I think the question is, to what extent is software copyrightable versus the music that software generates copyrightable? Is that the question?
Well, yes. Software is what some would say are just facts. Now, to me, it's a language that's expressive, no different than English, or, well, actually much more expressive than English. And it's just a language of sorts. And so I would discern that as being the difference, is that this is merely a language and not expression itself. But when you express yourself with facts or characters, ASCII characters, are you subject to the same kinds of limitations as you are with music?
I suppose that's true. And I would say that in addition to being the things that you said, expressive and otherwise, is that software is also, in addition to being expressive, is also functional. I can do things with software, and with software, I can actually make things happen. So in that same way, software is a lot like the law. The law is nothing but words, but through the words, effectuates change. And so in that way, there's a lot of parallels between software being language and the code of statutes and cases also being language that effectuates change. And the change that music software creates is, of course, is creative, I guess, in a sense, that you're able to, I guess, create a change in somebody's emotion based on the music that's generated. So at any rate, so I don't know if that's, so to what extent are any of those things copyrightable? Is the software that makes music copyrightable? Probably, even though it's also functional. Is the music generated from software copyrightable? The US would say no, because the US Copyright Office has said no, but the UK it's generally accepted that machine created works are copyrightable. So an open question is, if the UK recognizes all the music data set of 200 billion melodies that a machine created, if the UK recognizes that, and under the Berne Convention, if the US has to recognize other Berne signatories' copyrights, at least the copyrights they recognize, if the UK recognizes it, then
I'm patient. You'll be back.
I know he will be. What a nightmare. Comcast and, in this case, T-Mobile are not our friends today.
That's right. Can you hear me now?
Yep. Now,
right.
Look, the devil's been spending a lot of time in Georgia. And we've had a big Supreme Court case out of Georgia. And no doubt there'll be more court cases in Georgia, but there's been one recently that's really mattered a lot. My understanding is Georgia wanted to copyright the annotations of the state code. So if you really wanted to read all the law, you had to spend $400 for a book of it. And that's been challenged by Brewster Kahle at the Internet Archive. They published this for free, and now they've had a victory at the Supreme Court. Any comments on that and how it affects your company, Fastcase?
Yeah, so that's a very important case related to the founders, Ed and Phil's vision to democratize the law, and that the law is the people's law and not shouldn't be copyrighted under any one. I, as a citizen, shouldn't have to pay for the thing that I'm bound by. I shouldn't have to pay for my statutes. I shouldn't have to pay for my cases. I should be, if I'm going to go to jail potentially based on something, I shouldn't have to pay to figure out what I'm going to go to jail for. So this Georgia case that you mentioned kind of goes to that question. Under that case, the basic facts are the Georgia's legislature wrote the statutes, but as lawyers know, the statutes are one thing, and how the courts interpret the language of the statutes is a totally different thing. So an ambiguous statutory language can be clarified based on how the courts have been able to say what happens. So the Georgia legislature contracted with a large legal publisher to say, hey, legal publisher, why don't you collect all the cases that apply to these statutes and give summaries of how the cases have applied them. And we at the Georgia legislature are going to oversee that process and essentially give it the stamp of the Georgia Code annotated. And so if I'm a Georgia lawyer, I rely on that annotated version because both the statutes language and the cases, I need them both together to really be important. So what the Supreme Court case was about is saying, can Georgia require you as a citizen to have to pay for that second half to be able to not be able to get the whole picture, if you will. And the Supreme Court said, if the legislature has contracted with a third party, that doesn't matter. It's still essentially an edict of government. If edict of government, then it needs to be free, is essentially what the U.S. Supreme Court said.
Yeah, and by the way, that's a good decision in my opinion, but I have to say that I like the idea of a 35-year reversion statute as regards Georgia laws. The idea that they disappear after 35 years upon request in the case of Georgia would be, I think, a very good idea.
Kind of like term limits for statutes.
And yet we have, just to be absolutely clear, we now have a Supreme Court decision that says that government, when it acts as government, cannot be an author for the purposes of copyright. And this is our Supreme Court. This is an important decision, I think, for everyone to be cognizant of. And it may had a big effect on Fastcase, didn't it? Because your ability to use those laws, keep them in a database, we don't have to debate Feist as it applies to these things. That's an important decision that lets the world move forward in some really positive ways.
That's right. Yeah, now, the world is better off getting more access to governmental information.
Now, some people want to know how long it takes for you to generate all these melodies. And we'll assume you really are doing it and that some machine is doing it. Tell us something about the practicality of that. What is the machine? How long does it take this machine? Do you want new CPUs? Is there a GoFundMe for that?
Yeah, so that's a really good question, and it gives me the opportunity to sing the praises of my collaborator, Noah Rubin. It shows how—
Noah Rubin,
who is one of the smartest people I know, and certainly the smartest coder I know.
Why is he not in this room?
Hey, that's a fine question. He should be, and maybe in another room he will be. He wrote a code originally in Python, which is a language that was going a bit too slowly for his taste, where it was going only at about 10,000 melodies per second that was being generated. So he rewrote the entire program in a newer code called Rust. And under Rust, it was writing to disk at the rate of 300,000 melodies per second. So 300,000, 600,000, 900,000, over 1 million. So it's now, that's the rate that it's generating.
Very creative.
Very creative. And so the question I have for musicians is, when you think about what you want to protect under copyright, so my life plus 75 years or under institution, 95 years or whatever it is, do you want to give anybody a monopoly on something that a computer can spit out at 300,000 per second? Should that be something I get copyright on? Or should I instead focus on the thing that really makes me a musician? That's the ache of my voice, the way I play my guitar, the sensitivity that I finish out that phrase, the lyrics that I make. None of those things are touched by our project, but all of the things are really what makes musicians musicians. Musicians are not musicians based on the change in pitch, which is what all the music does. Musicians are musicians from their passion, and computers can't match the passion. Let's copyright passion. Let's not copyright the change in pitch that is finite, that people can accidentally step on.
But of course, computers could generate speeding tickets in Washington, D.C. much faster than that.
That's right. That's right. And that gets to the point that, will machines eventually be able to create that passion? And there are some algorithms out there that are trying to mimic, the stuff that is crescendos and decrescendos, and being able to mimic what really gets listeners really excited about music. And so that is another question for another day. Ours is using a very rudimentary, brute force approach. As people do it more nuanced music that actually people love listening to, that's another question. Is that copyrightable?
Now, you being a lawyer, I love this notion that you worked on autonomous cars, or that you did work around, you certainly wrote a law review article, if I recall correctly, about autonomous vehicles, which I think really becomes quite amusing when you imagine a billboard at a major intersection asking people for claims that they've been injured by robotic automobiles or robotic drivers. It's something like Better Call Saul in a way. There's something funny about that. But tell us, in your work writing about autonomous vehicles and thinking about the law around autonomous vehicles, did you see parallels to what you're doing now with regards to intellectual property in music?
Absolutely, and certainly parallels with my work at Fastcase, and I worked for another large legal publisher before Fastcase. And so there's a big worry in the form of the populace saying, am I going to am I as a truck driver going to get replaced by a robot car? And the similar worry is, am I as a lawyer going to get replaced by a robot lawyer? And there's technology has moved so fast that those fears I can certainly understand where they're coming from. I guess it should be comforting to those who ask those questions that the answer to that is no, you probably shouldn't be worried anytime soon. And there's the more I work with people that are deep in autonomous vehicles, both building them, writing the code for them, overseeing companies that are building these things, and regulators who are very in touch with the way that these things are being built. The people who know the most about autonomous vehicles are the people that have the least confidence that it's going to happen anytime soon. They think that that the runway, if you'll pardon the pun, of autonomous vehicles going on the road is much longer than people worry it is. That's thing number one. Similarly, thing number two, for software and autonomous is there going to be a robot lawyer anytime soon? I would say absolutely not, because humans have to make the decision: is it going to be a shape or is it going to be a color? Humans have to be able to make those human decisions in a way that machines can't now, and I can't see them happening anytime soon. I think what will happen is the drudgery of the law practice and the drudgery of driving a car. Machines are going to take away the drudgery and let people focus on the things that matter the most. That is, if I'm a lawyer, my favorite part of my job is counseling my clients. So if a robot can spit out a brief and be able to say, okay, this is the first draft that I can then curate, that's all the better. If a robot can spit out the likely risk threshold, you're 13% likely to get sued, that gives me more information to talk to my client and do the work that really brings my client the most value. So at any rate, I hope that answers your question, that there are parallels between autonomous vehicles taking our jobs and autonomous software taking our jobs. I don't think it's going to happen anytime soon. In the music industry, the musicians, the thing that makes their audiences love the music is not something a machine can spit out. The story behind the music and the passion with which the music is made, that's what brings audiences. Robots don't have that.
I'm somewhat relieved, because I was a little worried that you were some kind of advance guard to replace humans, maybe deposited here in some way to soften us up for AI and our overlords imposing themselves on us.
Well, Jim,
Yeah.
I will say that, if I were one of those, I would want you to be, saying, oh, thank God that's not true, because then I can be able to work my wiles even better.
Yes, that's probably true. I look at it and I say, AI versus smart humans. Who's going to win that battle? Where do you come down on that? Which side are you on? Damien?
I would say that for most of my lifetime, I'm 45 years old now. I would say for the rest of my lifetime, I can't see what artificial general intelligence, which is I think where you're going to, essentially machines being self-aware and being able to take over the world. It's really hard for me to see, based on the state of where we are right now, that happening anytime soon. Because for as smart as our AI is today, it's really dumb. And it requires a lot of humans in the background tweaking a lot of levers to make the end user think that it's magic. If the end user were able to see, I've worked in some of the largest companies, global software companies whose names you know that I can't say, that everyone to a person has armies of humans making the machine seem smart, because the stuff that they get from the machine is so dumb that they have to massage it and then feed it to the end user, so the end user thinks that the machine is smart. There's an idea called the mechanical Turk. That is, in the 1800s, this machine played chess, but it turns out it wasn't chess. It was just a guy under the table who was actually moving the pieces around. That was the mechanical Turk. And so I would argue that so much of AI is mechanical Turk-like, in that the stuff the machine spits out is dumb until we actually process it with human intellect and be able to spit it out in a way that seems magical.
Do you think we'll be able to separate the wheat from the chaff? Do you think we'll know that which is generated by machines from that which is generated by humans by some kind of signature or unique property that it conveys?
That's a really good question. And what you're asking about largely is the Turing test.
Yes.
The Turing was a computer scientist who said, at what point is what a computer spits out indistinguishable? Do I, as a perceiver, a listener or a reader, can I tell the difference of whether that's a human speaking or whether that's a machine speaking? And I think that the distance between knowing what is human and what is machine is really shrinking exponentially. I think that there's we've talked in your list, the FA list, we've talked a bit about there's something that says these lyrics do not exist. And so what they've done is be able to ingest a whole bunch of lyrics. So if you go to these lyrics do not exist, you can input country song that is happy, that is generally talks about these topics, and it'll spit out algorithmically a whole set of lyrics. It'll spit out verse, chorus, bridge, chorus. And so the question then is, and some of them are actually pretty good. The bar for creativity in copyright is really low. It just has to be a modicum of true creativity.
Especially in country music.
Yeah, especially, right. I'm not going to disparage any particular music, but yeah, so certain genres, right, there's repetition is a very big part of it. And the simpler the lyrics, the better for the audience. So if that's true, query how much different these lyrics don't exist is different than what a human would create, and whether one could tell the difference. And so to kind of press this forward a little bit further with my All the Music project, based on our discussion in the FA list, as soon as I discovered that these lyrics don't exist, I took melodies from my All the Music data set, which maybe are fact, which are not copyrightable, took those melodies, set them to the lyrics that these lyrics don't exist, spit out for me. I selected country music, sad song or happy song, and fast tempo. And then I sang those computer-generated lyrics to computer-generated melodies in a way that I think it's not going to win a Grammy Award, but I think if I filed that with the Copyright Office, they would put the stamp. They would say, yeah, that song is copyrightable. Even though the lyrics were written by a machine, even though the melodies were written by the machine, and I could have gone one step further and said, based on these melodies, write the chords for me too. So, and I was using virtual instruments to be able to play the piano and the guitar and the string section and these others. So if the machine is creating all these things and you as a listener don't know that all these things were made by a machine, but they think Damien Riehl created the machine, created the song, where does that leave the Copyright Office? Does the Copyright Office need to ask me in a questionnaire, hey, did any part of this get created by a machine, the melodies or the lyrics or any other aspect of it? And do I, as somebody submitting to the Copyright Office, have to say yes or no? And if I say yes, some of it was, is that not copyrightable? And if I say no, and it actually was made by the machine, is my lying a basis for the copyright being rescinded? And if that's true, if I lie on my application.
Oh, wow, we lost him at the moment of truth.
Well, we need him back. I say that because he's such an interesting fellow. And Alan Turing was an interesting guy. He brought up the Turing test, and Alan Turing was one fascinating Brit, I'll tell you.
I'm back. Are you guys, can you hear me?
Yeah, and I mentioned that Alan Turing was one fascinating Brit, and you are a really interesting American. And I do declare you human. Not that it's up to me to declare that. By the way, I don't think the Copyright Office should decide what's deserving of a copyright either.
Right.
You know, it doesn't strike me that any human could stand in judgment of that.
The last sentence that I was going to say that is really interesting. So if I lie in my application and say no machine is done, and I sue somebody, it would come out in discovery that a machine created my lyrics and underlying melody and chords and other things. So does that nullify my copyright?
These are interesting questions. And I would say that for a fuller picture of Damien, I would ask those who are watching to review on the net him singing Ave Maria, which was surely created by angels. And he's no choir boy, I don't think, but it just shows that Damien really is a musician. You know him to be an attorney. He is certainly a technologist. He didn't mention it, but he began programming at age 12. It took him 10 years to get around to websites. But I hope you know better now, my friend, Damien Riehl. I think he's acquitted himself well in spite of these disappearances of connectivity. On-off nature of it is certainly sad. But I think we've had a good hour with him. And I'm going to call it here because I know we'll get trapped into a discussion that will go on past 3 o'clock. And billable hours being what they are, setting an hour aside for hearing us go back and forth, I think is generous. And I'm very appreciative for your time.
Well, thank you,
really
both Jim and Tom. I really, being exposed to your FA list, and Tom was the one who introduced me to Jim in the first place, and the FA list. I will say that being a part of this list has been one of the great joys, bringing together all the passions, my technology passion, my musical passion, and my legal passion. Those are all exhibited in full force in FA. So thanks so much for that list and for this conversation. I really appreciate it.
Yeah, look, if anybody wants to be on the FA list who's watching this and isn't, you can write me at griffin@onehouse.com, and that's pretty easy to look up online through Google or whatever. And really the best of that is the soup itself, which we gather around, and there's nothing quite like a great bowl of pho with a super bowl of broth and so forth. And I'm looking forward to getting back to that at some point where I don't have to be wearing this mask, which I'm happy to wear to keep everybody safe. So I'll let you go with me putting this mask on. And thank you again for the work that you provided us and the explanations you've given and introducing us to Fastcase. Thank you so much, Damien.
Thank you so much.
Thank you, Tom, for having me.
Hey, thank you to Jim and Damien for sharing your wisdom freely. I also want to say, you know, we don't charge for this knowledge transfer, but if you're interested in learning more about either one of these geniuses, they're both on LinkedIn. Hit them up. They're as nice a guys as they are smart guys. Let me close by giving one more shout out to next week's program. We are going to be featuring Bob Lefsetz in very much the same format as today, and Bob and Jim will be going at it for about an hour, talking about all sorts of different topics. You can find that online. I will be sending out an invite for this, but nonetheless, we hope that you'll join us. And I appreciate your attention today, folks, and thank you for your time, Jim and Damien. Stay safe out there, folks.
Be well.
Thanks, everyone.